Hello everyone. Today we are going to understand that how to answer questions in college exams, particularly law school examinations. So first we must understand that what are the factors which determine the structure of our answer. Firstly, the marks allotted to the question. Secondly, whether the question is plain or application based. So for example, a plain question can be explain the essentials of a valid contract, define contract of guarantee, distinguish between contract of indemnity and contract of guarantee. Then, what are applied questions? This is an applied question. A contracts to take in cargo for B at a foreign port. A's government afterward declares war against the country in which the port is situated. What will be the effect of the war on the contract? Can the contract be enforced? Justify your answer with relevant provisions and case laws. So let us see how we answer these two types of questions because these are the two main categories or the forms in which questions are asked in law schools. So for what will be the structure for a plain question? So for this question, explain the essentials of a valid contract. First of all, a student must discuss the purpose of having a valid contract. Why do we need a valid contract? And what is the uh, purpose of having the contract? The purpose is to provide safeguard against breach in the form of compensation. So, for example, if there is a breach, then of these essentials, then we have a remedy in the form of compensation because the contract will be either valid, either void or voidable. So, accordingly, we will have the remedy of compensation or specific performance or other reliefs in specific relief act. So that is the purpose of having the essentials. Now, what then after the purpose is discussed, the student must discuss the relevant provisions. So relevant provisions are contained in section 10. So the section 10 will be discussed, and if there is any maxim related to the question, then that also must be highlighted. Then each of the essentials, so there are five essentials. So each essential should be answered one by one. And while explaining the essentials, each relevant provisions of those sections. So for example, when the student is explaining competency of party, then section 11 and 12 should be highlighted because they are the relevant or related provisions. Then the purpose of each essential can also be highlighted. What is the policy behind having each and every essential? Then the relevant cases such as Mohori Biwi should also be cited while explaining the essential of competency of party. Then after the all the five essentials have been discussed, then the effect of absence of any of these essentials should also be discussed. That what will happen if the one of the essential is missing. So for example, if the party is incompetent, that what will be the effect of the contract? So similarly, if there is mistake of fact, then what will be the effect? So for a mistake, for example, we have the effect of that the contract becomes void. So in effect, you must write that if there is absence of if there is mistake, then the contract becomes void. So that is the effect. But that the part of effect should also only be discussed when there is sufficient time left to the student. Then lastly, after the purpose, essentials, and the effect, last comes is the conclusion. So in the end, the student must conclude the question, and conclusion is not a repetition of what you have already discussed, but you must highlight in the conclusion that what are the challenges in these essentials. So there may be some issues relating to the changes which are required. For example, in competency, you think that there needs to be a change, or there is a current debate ongoing. For example, in Hindu law, the problem of age of marriage, it is debatable, and there is a huge debate going around that what should be the age for marriage. So, in conclusion, issues like that should be addressed instead of just re-narrating what we have already discussed in your previous segments of the answer. So, next is the what will be the structure of an applied question. So what is an applied question? I've already given this example. So now this question, first of all, we must carefully read the question and we must be able to answer in our mind that to what provision the question relates. So this question if it comes in examination, this is an illustration of section 56 relating to the impossibility of contract, performance of contract. So we must be able to remember in our mind that what is the relevant provision relating to the illustration of the applied question that is given. And this is comparatively a simple applied question. There may be multiple sections applicable to a question. So accordingly, we must first jot down the relevant provisions and the relevant case law, then we must come to answering the question. Now, how this question has to be answered and what is the difference between answering a plain question and this kind of a question. So, as I've already told that we must identify the law relating to the problem, that is the important provisions which are related to that. Now, after we are able to identify the relevant provision, we will discuss the provisions in a similar way that we have answered for a plain question. So, till here, there is no difference. You are going to again re-narrate that what is section 56 and what is the maxims that are applicable there. What is the purpose? For example, the purpose is that if there is impossibility, then the contract cannot be performed. So that safeguard is provided in form of section 56. Now, after that purpose has been discussed, we should discuss the maxim that add that is impossibilia maxim, less non-cogit add impossibilia. So this maxim that is related to 57 should also be discussed after discussing the purpose. Now, the essentials of section 56 can also be discussed. So that, for example, that there is initial impossibility or subsequent impossibility, then there is issue of physical impossibility, whether physical impossibility is a form of impossibility provided under section 56 or not. Okay, so physical impossibility is not provided. That is not the kind of impossibility that section 56 safeguards against. So that can be discussed. Now, after all this background has been given like a plain question, now we must come to the facts. Now we must what is the difference between applied question as against the plain question is that we will be relating the facts to the law. So we know that there is what was the let us go back. Let us now see that what are the facts and how they are related to this section. So there was an agreement for there was a code and there was this contract of supply. Now there is a war, so the contract cannot be formed. Now these facts are very similar to this leading case of Satyabrata Ghosh versus Mugni Nambango. So we must be able to first highlight this case and what was the decision. So why we are discussing this case is because this case is giving us the law. What was the law relating to impossibility and effect of impossibility? So we must highlight this case. Now we must distinguish the given facts and the facts of this case. So what was the difference between the illustration that is given and the facts of this case? And lastly, when we have discussed both the cases, we must give our decision. And after we have given our decision that what will be the effect, whether the contract will become impossible to perform or not, after that we must come to the conclusion. So decision will come before the conclusion. So that is the main difference, the application of the law to the facts. Other than that, there is not much difference in answering a plain question and an applied question. So that is all for answering the plain question and applied question. And this is only a standard structure, and the best structure always comes from a student because there are always good students who keep on writing good answers. And if still there is any query, you can always write in the comment section, and I will try to answer their queries. Thank you.